And welcome to the Aaron Katzman Show. I'm your host, Aaron Katzman. We speak about your life, your money, and your investments. And as always, we're coming to you from the spiritual and soon-to-be financial capital of the world, Jerusalem, Israel. If you like this content, please hit the like button below. If you've not yet done so, please subscribe to both the YouTube channel and to the podcast. And if you think somebody might actually benefit from this information, feel free to hit the share button and share it with them as well. So I recently got a phone call from someone who wanted to know what they could do because their spouse actually tragically suffered a stroke. It was a pretty debilitating stroke, and they're not young. And it got me to thinking, and it's an issue that financial advisors have all the time, and that's trying to give advice to clients to anticipate the future, right? We should never need it. But what would you do? How can you ensure continuity, let's say, of finances in the event that somebody becomes incapacitated? That it's a big issue, and you really, really need to think about what your solution is going to be. Because if somebody becomes incapacitated, especially when they get older, they're going to need access to their money, and they very well might not be able to do it because they're no longer able to make a phone call, right? Because they are now incapacitated. I came across a really interesting article by Beth Morrison and Amy Erickson, and they say the following: incapacity can affect anyone, young or old, and can present unexpectedly, such as in the case of a sudden accident or debilitating health condition. Putting in place the right estate planning tools can ensure that an individual's wishes are respected and their assets managed appropriately should they become incapacitated. They're going to speak about, issues that deal with this. I would say a little bit different, right? It's important that the individual's wishes are respected, but it's also important that the individual has, one way or another can use the money, or the money can be used, probably is more correct to say, to potentially deal with any kind of, let's say, medical conditions or what have you that they may have. Okay. The article continues: estate planning tools for diminished capacity. Several estate planning documents are specifically designed to take effect when someone becomes incapacitated. These documents allow an agent to step in to manage the individual's affairs consistent with the estate planning document and the individual's wishes. Number one is power of attorney. She writes, a durable power of attorney allows an individual to appoint an agent, also called an attorney in fact, to manage their financial affairs if they become incapacitated. The attorney in fact can be legally authorized to handle tasks such as paying bills, managing investments in real estate, handling court claims, and managing benefits. When planning for incapacity, a key consideration is choosing a trustworthy attorney, in fact, who understands the principles, preferences, and values. If an individual becomes incapacitated and does not have power of attorney in place, the court may need to appoint a conservator to manage the individual's affairs. That's where things get really, really complicated. So I can't stress enough that issue, right? A power of attorney is definitely one well-used tool to, I would call, enable continuity. We often don't appoint powers of attorney for youngsters, right? So nothing here is foolproof, right? God forbid if tragedy strikes, an accident happened to somebody in their 20s, 30s, even in their 40s, unexpectedly. Sometimes you're getting stuck, but if you have a joint account or whatever, that can go a long way in helping you sort of doing end around any kinds of incapacity issues. Most of this is for someone who is older, or, and we spoke about solo aging last week, individuals, right? People who don't have joint accounts, joint finances. The next thing is a healthcare directive. A healthcare directive, or medical power of attorney, designates someone to make medical decisions on the behalf of an individual if they are incapacitated and unable to do so. The healthcare directive, or a separate document called a living will, outlines an individual's preferences for medical treatment in situations where they cannot communicate their own wishes. This can be related to life-sustaining treatment and end-of-life care. If an individual becomes incapacitated and does not have a healthcare directive or living will in place, the court may need to appoint a guardian of the individual's person to make medical decisions on their behalf. Again, something you totally don't want to do, especially if they're older, right? And keep in mind that older patients, certain times hospitals, may not want to treat, or certain times they definitely want to treat where you know that that's going against the wishes of the patient, of the parent, whatever it is, and you realize that sometimes, it might be better for them to pass in their own bed in a house than being stuck in a hospital for months with tubes coming in and out just so they can be kept alive. These are big, big issues, right? Don't look at me, right? Each one is on their own, but you can get guidance, in our faith, you can get from a rabbi, any kind of pastoral help. There are definitely people out there who deal with kinds of issues, but not on the decision, but on a way to help make decisions be processed. Again, having some kind of directive in place is worth its weight in gold. Finally, in terms of estate planning, they speak about revocable living trusts. A revocable living trust allows an individual to place their assets in a trust managed by a trustee. The individual can appoint a successor trustee to take over an event of incapacity or death. Establishing a revocable living trust can avoid probate and provide a seamless transition of asset management from the individual to their selected successor trustee. Again, incredibly important. Also, in terms of dealing with end-of-life issues, probate, especially if you're living abroad, trust can serve huge benefits with sort of foregoing the need of an IRS transfer certificate to free up funds for the heirs and what have you. So trusts definitely serve their purpose in estate planning, not just to avoid probate. Those of you who live in Israel, some of these issues, endurable power of attorneys are very, very important because it allows you when people it only kicks in when people become incapacitated. So you can help them with their finances or medical directives. There are a whole bunch of others, subcategories there that you can also do, but those are the two big ones, finance and healthcare. So this is a lot of food for thought, right? Think about this, but it's very, very important. It's also very, very important not to procrastinate too much. You should be thorough and should think these issues through thoroughly and pick the right people for each specific situation. Who is going to be, the agent. But like I said, I can't stress enough, especially for older individuals, this is very, very important to get these issues set in place in writing. It'll help you with your finances. It'll help you with your health. And it'll also help your children or whoever's looking after you because everything's written down, right? And everybody who's able to, we know you made a directive, who is going to be responsible for what, who can make decisions for what in the case that, God forbid, you become incapacitated. Okay, very, very important. You've been tuning into the Aaron Katzman Show. We speak to you about your life and money and your investments. If you like this content, please hit the like button below. If you've not yet done so, please subscribe to both the podcast and to the YouTube channel. For those who you think might benefit from this, hit the share button as well. Thanks so much for tuning in, and we'll speak to you soon.